Donald Trump will get his day in court next week, Tuesday, defending why he should not be held criminally responsible for attempting to overturn the 2020 election and for the insurrection that happened 3 years ago today. Trump is banking on the long-shot idea that being president at the time afforded him absolute immunity for his official actions. But 16 conservative Republican lawyers are firing back by filing a damning amicus brief rebuking Trump's claims of immunity and holding him to account for his crimes. Joining me now is attorney and board president for the Society for the Rule of Law Institute, George Conway. George, it's always so good to see you. Let's start with those oral arguments that are coming up this Tuesday on January 9th. This was an expedited process. The presidential immunity and double jeopardy defenses are at issue. What are your thoughts about what we're going to see on Tuesday?
Well, I think you're going to see some intense questioning from the panel. It's a very smart panel, a very able panel. This is basically what many people consider to be the second most important court in the country. And I think it's going to be, my way of judging how appellate arguments go is who gets the most questions? Who gets the most questions, there's like a 60 or 70% chance that that person is going to lose, or that their client is going to lose. And I'm pretty sure that the questions are going to be coming fast and furious for the party of the lawyer representing Donald Trump, because I just don't see, for the reasons we set out in our brief, I just don't see how he can possibly prevail in this case. And I wouldn't be surprised to see a quick decision, a decision that I think the judges may well be already writing, because I don't think this question is close. I think a decision within a matter of days will be in order. And the interesting question would be, maybe the Supreme Court doesn't even have to weigh in if the Court of Appeals opinion is sufficiently compelling.
George, let's talk about the fact, though, that that order was entered by that three-judge panel at the D.C. Circuit Court of Appeals, ordering both sides to be prepared to answer questions about issues that were raised in amicus briefs, including the one that you and the other conservative lawyers filed. I thought it was particularly noteworthy because amicus briefs get attempted to be submitted all the time, but it's interesting to see an appellate court panel say, not only are we accepting these briefs, but we want people to be prepared to answer questions about them.
Yeah, well, I've seen that before. It's happened in a case in cases in which I've been involved in, where the courts actually go out and seek amicus briefs. But in this particular case, I think there is one brief, not ours, that is going to be the focus of some attention, and that is a brief filed by a group called American Oversight. And they argue that the Court of Appeals doesn't even have appellate jurisdiction to hear this case. And their argument is basically that you can only have appellate jurisdiction, interlocutory appellate jurisdiction, which for your viewers who aren't lawyers, that means jurisdiction to hear claims of error that are committed, to correct those errors before there's a final judgment of conviction. There are strict rules against interlocutory appeals in the federal courts, and the argument there is that there isn't a sufficiently clear statement in the statute or the Constitution that there is an immunity for the president, that there should be no appellate jurisdiction. I don't think that argument at the end of the day is going to prevail. I think at the end of the day, they're either going to say, if they say there's no jurisdiction, the court's also going to say in the alternative, there is no claim. And I think at the end of the day, if the questions merge, if there really is no presidential criminal immunity of the sort that Donald Trump is seeking here, and as a result, you could argue that that also means there's no right to appeal.
I think Clyde is agreeing with you as you speak to us right now, George. George, let's shift gears and let's talk about a case that actually leapfrogged this particular D.C. 1-6 case for Donald Trump, and that is that Colorado Supreme Court decision that has now been granted cert by the Supreme Court to be heard. You've been very vocal about that case and about Section 3 of the 14th Amendment. I want to focus on one particular nuance for our viewers today because, George, I think this is a really important part of what's going on. I think factually, he's the president of the United States at the time, he being Donald Trump. Factually, I think the office of the president is an office of the United States for purposes of this amendment. Let's talk about whether or not it is needing an enforcement mechanism. We see a lot of that language in these briefs. I want my viewers to understand better what we're talking about when we talk about whether or not Section 3 of the 14th Amendment requires Congress to pass a law to actually say who is going to enforce that section and how it's going to be enforced.
Yes, Section 14 of the Constitution, the 14th Amendment of the Constitution of the United States is actually a relatively short provision. It consists of 5 parts. The first one is the part that says that states cannot deny people equal protection of the laws, which is referring really to race discrimination and other forms of discrimination. And Section 3 is one that hasn't been thought about in a very, very long time because it involves what we're talking about here, which is whether or not people can assume office if they've previously broken their oath to the United States or to the United States Constitution by engaging in insurrection. The argument here is that it is based upon Section 5 of the 14th Amendment, which says that Congress, by appropriate legislation, can enforce the other provisions of Section 14. And that's one of the bases that has been used for the Civil Rights Act of 1964 and all the other the civil rights acts that were passed during Reconstruction, virtually any civil rights act against racial or other forms of discrimination. Congress has invoked Section 5 of the 14th Amendment. What Trump and his allies are arguing here is that for Section 3, you must have congressional authorization or congressional enforcement legislation enacted in order to enforce Section 3. But that argument is bogus because Section 3 doesn't say that. Section 1 doesn't say that. And if it were true that Section 5 required a statute to make Section 3 enforceable, the same would be true of Section 1 because they're completely parallel provisions, and there's nothing in Section 1 either that says that, which would mean that if Congress tomorrow, for whatever reason, repealed all the civil rights laws it had ever enacted, you could engage in racial discrimination tomorrow. States could do that, and that's just not true. And that's one of many reasons why this argument does not fly, and another reason is that the Supreme Court has made clear that provisions of the 14th Amendment are self-executing, and they don't need congressional enactments. And then also one more reason is that Section 3 says that Congress can relieve a person of the disability of having engaged in insurrection and being disqualified from office by a 2/3 vote. Well, if Congress, if the framers of the 14th Amendment provided that certainly means that somebody else could be imposing the disability, not Congress.
Yeah, George, very quickly, I just want to make sure that this is the way I understand it. You've got a Supreme Court that currently is comprised of justices that a majority of whom are strict constructionists, right? They're textualists. They're going to read the language of these amendments in the United States Constitution as they should be strictly construed. So if what you're saying is the case when it comes to Section 3, 1, and 5 of the 14th Amendment, then we should see a Supreme Court ruling or a decision that says that Donald Trump is disqualified from the ballot, right?
Yeah, to channel my inner Justice Scalia, we are not strict constructionists or loose constructionists. We read the text of the statutes, we read the text of the Constitution, and we try to interpret the words as they were understood when those words were written. And that's the problem that Donald Trump has here, is that the words are very simple and very clear. And in fact, they're clearer than other provisions of the 14th Amendment. I mean, the words equal protection of the laws, that's a capacious phrase. And it's not, it's very difficult just reading that to interpret it. Section 3 is rather narrow. It's not hard to know what an insurrection is. It's not hard to define an insurrection, and not many people engage in insurrection. So it's really not a difficult provision to understand or to enforce.
If it makes you feel any better, I have already put EVAC on alert. He's ready to go if it comes to that.
General, I can assure you.
Hey, General, let me into the war room to see you, so I had to hack my way onto this frequency.
This better be critical, Willie.
Sir, come on, when is it not? Please. Okay, couple of things. I'm running low on the dough. I was thinking about taking a couple of months sick leave, maybe starting today. And, oh yeah. I intercepted a transmission from Megatron.
Then send it through.
Yes, sir, right away, sir. And so I'll assume that we're caught on the other stuff.
This is your last warning, insects. Relinquish what remains of the Allspark.
So who's the insect? You? What?
The
Who's
other
the
ones cannot
insect?
protect you. They were defeated on our
way.
world, and we will defeat them here.
The Megatron.
This was just a diversion. Security, please bring up. Rabbit, she's already inside. Deeds! Give me an update on that reserve. Boss readiness. What was his name? What was it?
Evac, sir.
Right, evac.
She's right in front.
We are facing a heavy sustained attack. They appear to be after the Allspark craft. General Order! General Order! Need to evac immediately, General. Evacuate everything. Hold on. National security evacuation. Stand down. Check it out. There is a celebration for the amateurs for a suicide mission.